On April 19, 1952, 9 days before the San Francisco Peace Treaty took effect, the Director General of the Civil Affairs Bureau at Japan's Ministry of Justice issued an internal circular notice. Reference number Civil Affairs A number 438. Its content, as of April 28th, all persons of Korean and Taiwanese descent residing in Japan would cease to be Japanese nationals. It was a kairan, an internal memo circulated to relevant offices. The Diet did not debate it. Legal scholar Mark Levin described the mechanism. The involuntary de-naturalization was accomplished by administrative fiat. Japan's own 1947 Constitution, Article 10, states that conditions for being a Japanese national shall be determined by law. Mindan, the South Korean-aligned Zainichi organization, has argued in submissions to the UN that the notice was therefore unconstitutional. It stripped roughly 600,000 people of the citizenship they had held since 1910. These were people who had served in the Imperial Army, paid Japanese taxes, been forced under the 1940 Soshi Kaimei Edict to adopt Japanese names, in many cases forbidden from speaking Korean in school. The same administrative apparatus had argued the opposite just 4 years earlier. In 1948, when Koreans tried to keep open ethnic language schools they'd built after liberation, Japanese authorities ordered the schools closed on the basis that Koreans were still Japanese nationals and therefore had to attend Japanese schools. They had been Japanese long enough to have their native language schools shut in 1948. 4 years later, not Japanese enough to be stripped of citizenship and excluded from welfare in 1952. The category wasn't a fixed position. It was a switch thrown in whichever direction made the next administrative action easier.